Can you see it, Amy?
Nope. I'm on your page.
There we go.
I'm scrolling down. Video. Nope, that's not the right one.
We're going to let this populate and see if people show up.
How come I can't see it? Oh, there we go.
Yeah?
Yeah. There.
Perfect.
Perfect.
All right, let's wait. Let's give everyone a chance to show up. Welcome, everyone, to the Early Friday Happy Hour, also known as the Employer Handbook Facebook Live Chat. You may notice something a little bit different today. I want to try not to bob and weave and get behind the camera. We have a jerry-rigged setup. This is a little bit different this week. I said I had a special guest. My special guest this week, sitting on my iPhone in between two soap dishes with a couple of rubber bands holding her up, is my partner and employment law attorney extraordinaire, blogger Amy Epstein Gluck. Amy, how you doing?
Hi, everyone. Hi, Eric.
Hey.
Thanks for having me today.
Thanks for being here. I'm going to let this populate a little bit more. The one disadvantage I have, because I'm streaming today from my computer rather than my iPhone, is that I don't know how many people are in the room. I can see comments as they come by. So we'll give it like another 30 seconds to get going. And then we'll do a proper introduction.
I like all the people from all the different places.
Oh, yeah.
Very cool.
Yeah, good morning. Let's see, we have good morning from Boston. Hello from Boston. Go Bruins. Hello from Minnesota. Shout out Green Bay. Marysville, Ohio's in the house. Oh, hey, Steven, how you doing? Client right there.
There's Christina.
Hey, Christina. Yeah,
yes.
At least this is some serious social distancing Facebook Live action going on. So let's get started. I'm going to do a proper introduction. Welcome everyone to Facebook Live chat today, the Employer Handbook. My name is Eric Meyer. I am a partner in the employment practice group at Fisher Broyles. I'm also the publisher of theemployerhandbook.com. The Employer Handbook, which is at theemployerhandbook.com. And you can check me out also at fisherbroyles.com, FisherBroyles. But there's someone else you can check out at fisherbroyles.com. And that is my special guest today, coming to you live via iPhone with has had a very jerry-rigged setup here. It is my partner, Amy Epstein Gluck. Amy, how you doing?
I'm great, Eric. Thank you for having me.
Why don't you tell the audience a little bit about yourself?
Okay. So as Eric said, I am also a partner in the law firm of Fisher Broyles. I am actually employment counsel for the firm and manage the firm's more than 125 employees. I have an employment law and business litigation practice, and I'm coming to you from my basement office in the DC metro area. So I really appreciate Eric and I work a lot together on employment compliance matters as well as employment defense matters. So I'm thrilled to be here.
Yeah. So before we get started, and I thought the first thing we'd talk about, Amy, without divulging any attorney-client privilege information, is what life has been like in the trenches, maybe. You know, FFCRA has been in effect since April 2nd, so a little over a week. Or April 1st, April 1st, a little over a week. And obviously we did some preparing for the enactment of the Families First Coronavirus Response Act. And you are one of our, I like to refer to them, we all refer to you guys as the dream team that handled the CARES Act stuff too. So I think the audience might like to know a little bit about life in the trenches. But before we do that, let's give a disclaimer. Amy and I are both lawyers, but we're not your lawyers. We're here giving advice today, but it's not legal advice. It's weird how this all works metaphysically. But trust us, we're not giving you legal advice. We consider all your questions to be hypothetical ones that you're asking for a friend. And nothing that we say or do here creates an attorney-client privilege. If you need legal advice, don't take it from a free chat on Facebook Live. That's silly. Call your employment lawyer. Pay for it. It'll be worth it. All right? So, Amy, gosh, I mean, yeah, we've been drinking from a fire hose this week. Not at the same time, a separate fire hoses, social distancing, all that. Why don't you tell the folks a little bit about some of the work and issues that you've been sorting out over the past, let's say, week or so?
Okay, I can do that. The issues that I've been dealing with are myriad. It starts with OSHA and OSHA's 10 additional tips that employers should be following in the workplace. They literally just issued a notice advising of a top 10 list. You know, we used to have top 10 music for the last year, but this is top 10 in the workplace, encouraging workers to stay home, limiting worksite access and such, as well as a reminder, as if anyone needed a reminder, not to retaliate against a worker for reporting unsafe or unhelpful working conditions. We also have additional guidance from the Department of Labor about the Families First Coronavirus Response Act, which is your paid sick leave and your expanded family medical leave, and all of those questions you guys have been sending to Eric and myself over the last few weeks. There's actually additional guidance and correction that came in, this morning?
Yep.
I think it was dated April 10th, that I'm just wrapping my arms around now. So it's just really talking about when employees can receive paid sick leave for a quarantine or isolation order, and if they need a medical diagnosis, things like that. There's also some information about the intersection with workers' comp. Another thing that big ticket item that came out this week is how the CARES Act is affecting unemployment. That's huge. That's huge because the CARES Act provided money to the state unemployment commissions to supplement what the state was providing to employees who had filed for unemployment. It's retroactive. It lasts longer than unemployment ordinarily lasts. So that was enormous. There's new workplace posters. There's new information about obtaining tax credits. Regarding the NLRA, we're seeing new guidance from the National Labor Relations Board about the National Labor Relations Act, where people are starting to gather together to potentially increase their wages or request something like hazard pay or incentive pay. And I've dealt with a few clients that are interested in that. I don't know if you guys have seen in the news, but there's a lot going on with Instacart and Amazon protests on work stoppage if they don't get premium pay. Sorry, something just came in. There's also additional information about the Paycheck Protection Program under the CARES Act and how that intersects with the Families First Coronavirus Response Act. A lot of confusion and a lot of questions. And those are just some of the things we've been fielding this week, along with new information from the Equal Employment Opportunity Commission about reasonable accommodations and other types of guidance.
Yeah, I hear you. It's been a lot. It's been a lot to absorb, even for us. We are kind of the I don't know if we can say this as a matter of ethics, but we are kind of the de facto experts on FFCRA and CARES and really it's only a couple of weeks old. So folks that are watching this, thank you for tuning in. But I can't stress enough how important it is that when you have questions, not just to rely upon us. I mean, we'll do what we can. We'll answer some questions today, but really talk to your employment law counsel to get answers to anything that we discussed today. And Amy just rattled off a laundry list of topics.
Right.
One of the things in the trenches for me that's been, I don't want to say heartbreaking, that's hyperbole, but difficult, is kind of getting to everyone and making sure that everyone is serviced properly. It's not that we don't have the bandwidth, because we do, but sometimes I get contacts from potential clients that want information about Families First Coronavirus Response Act, and it's small business, and they're standing on a precipice right now. Like, this could really put them out. And it's tough. Sometimes you can't get to them. I want to, we want to, but sometimes you just you can't. And hopefully it's sessions like these, and Amy does a lot of writing herself, and she contributes her time. But it's a tough, to be honest, it's a tough balance to strike between doing stuff like this and giving kind of letting people pick your brain, so to speak, versus making sure that your clients are also well taken care of. Are you feeling that kind of push and pull too, Amy?
Yes, and it definitely depends. I mean, the bottom line, and I think I can safely speak for both Eric and myself, is we want to help. We want to help. We want to give you accurate advice, but it's honestly the best advice that we have at the time. Often we'll tag team each other. If I can't get to something, I ask Eric to take it. One time he did this to me, and I'm like, no, we're not siblings. You don't get to say not it. So, we want to get to everyone. We want to help. We are available. Reach out to us. Eric's email, and if you just go on the website, you have mine as well.
Yeah.
Well, we are deluged. We're doing the best we can.
Yeah. So you mentioned, Amy, that there was some guidance that came out this morning from the Department of Labor. And I want to give a quick shout out to David Miklas, who's an attorney down in Florida. He gave me the heads up on this through a LinkedIn message. So what the Department of Labor has done, and this is going to get a little bit nerdy, is published in the Federal Register. That's where about 4 days ago, where the temporary rule that the DOL came out with was published. It's published in the Federal Register. And that temporary rule was what was supposed to fill in all the gaps from the FFCRA itself, because there were a lot of gaps, and we'd been getting a lot of guidance from the DOL on its website. There were a bunch of Q&As. There were, a page on FMLA, interplay with COVID-19, FLSA, interplay with COVID-19. We saw a poster, which you've now hung up in your workplace. But ultimately, the way that the DOL formalizes all of this is through rulemaking. And a temporary rule was published, and we heard about it on the 1st. It was actually published in the Federal Register on the 6th. And this morning, on the 10th, we got an update. And mostly it's just kind of capitalization, maybe changing a reference here and there for continuity and consistency. There was an example in the preamble to the actual rules where it said 7.5 hours, and they meant to say 6.5 hours. So most of it was non-substantive. But there was one notable change, which I saw, which I think is meaningful, and hopefully I'm not putting too much stock into it. And that is, the Department of Labor removed a paragraph from the preamble, which appeared to suggest that the employer and employee had to agree in a situation where an employee is taking expanded FMLA, or we'll call it FMLA plus, or whatever we want to call it, the rule number, the reason number 5, when you are having to care for a child because their school is closed due to coronavirus, or their daycare, their child care is unavailable. There was a paragraph in the preamble to suggest that the employer and employee could only agree to top off someone's wages during the final 10 weeks of that EFMLA. So you get paid, your default is, under the EFML, you get 2/3 pay up to $200 a day. And this paragraph seemed to suggest that all you could do was top off. That is to say, pay someone the delta between $200 a day, or 2/3 pay, and what they would ordinarily get paid, 3/3 pay. But they removed that paragraph from the preamble. What do I think that means? I think it is now clear sailing for employers to,
Pause me.
Yeah, I'm going to decline this call. That was a robocall from Washington D.C. Sorry about that, Aim. Um, what was I saying? So what I think employers can do now is I think if employers want to run paid time off concurrently with that 2/3 paid expanded FMLA, they can do so without employee permission. So just like you would under classic FMLA, right? If some classic FMLA, the default is it's unpaid time off. But if you want to run paid time off concurrently, assuming some employees have that in their bank, you can do that. And I think you can do that now. I think it's relatively clear you can do that now, at least for the final 10 weeks of EFML. For the first 2 weeks, definitely not as clear because it says in the statute specifically that you can't force an employee to run paid time off before they take paid sick leave. And the expanded FML by default is unpaid. So by forcing an employee who wants to take that leave unpaid, forcing them to use their paid PTO at the same time, I think would violate the statute. That's my read on it. Again, you don't have to trust me. You talk to your employment lawyer, but I think that's there you go, Amy. Sorry, I'm trying to figure out the best way to do this. That's what we saw today. I think that's a pretty big change. Amy, some other guidance came out recently that I think we should touch upon, and that's the EEOC guidance that came out yesterday that blogged a little bit about today. And I wanted to talk a little bit more about the reasonable accommodations. And maybe not so much to focus on what the EEOC has said specifically in their guidance, but I just want to ask you, Amy, in the past week or two, have you been encountering issues with clients dealing with reasonable accommodations in COVID-19?
Have I dealt with it this week? Not really. Not really this week, but I was very interested. I mean, I was surprised that this was an issue for people, actually. The ADA still applies, even though we have all these new regulations and such, and employers still need to engage in the interactive process in order to determine what accommodations may be reasonable for the employee, depending on the employee's physical or mental health issue.
Yeah.
So, I mean, I was kind of surprised that had to be said, to be honest.
Yeah, they were talking about, someone who might be suffering through depression or has some mental health issues to begin with that the COVID-19 pandemic could exacerbate. And yeah, I mean, in that situation, you would provide a reasonable emphasis on reasonable accommodation if you can. But what is reasonable now versus what was reasonable a month ago has certainly changed. And hopefully allowing people to telework if you're not an essential business. I'm not a mental health expert, but I think that could alleviate some of the stigma or fear of, coming into the workplace and or at least being afraid of coming into the workplace because you're afraid that you're going to get coronavirus that way. So some of these issues may sort themselves out. But one thing I do want to emphasize is that, and I've fielded this question a few times, we'll get questions about older employees, folks that are immunocompromised. And the question is, do we have to make accommodations for them? And the answer clearly is no. If it's about age alone, the answer is no. The EEOC has said that there is no duty to accommodate under the Age Discrimination and Employment Act. But what I've been telling clients is that if the employee gets a doctor's note, right, and all of a sudden it becomes about a disability, maybe this person has an underlying disability and that's why they are immunocompromised. It's not just age. Then it becomes an ADA conversation. Similarly, if someone is pregnant and needs an accommodation, you are obligated under the Pregnancy Discrimination Act to provide a reasonable accommodation, just as you would to someone who is similar in their inability to work. So pregnancy is not a disability. There is a duty to accommodate. It's not exactly the same as the Americans with Disabilities Act, but there is that duty to accommodate. So think about the types of accommodations that you're giving to other folks who aren't pregnant, who have the same inability to work, and those are the types of accommodations that you should be giving to pregnant employees.
Well, let me ask you a question, Eric. A word about the reasonable accommodations for employees who work for essential businesses under whatever state orders they're under and have to be at work. So the new EEOC guidance is talking about one-way aisles and plexiglass tables and other barriers. And then it says, or other accommodations that reduce chances of exposure. That's the question I'm getting. When we're talking about accommodations, what other ones are there?
Right.
What could that be? And I think the answer is it depends on the workplace. And I wasn't exactly surprised that the EEOC provided that catch-all, saying other accommodations. I think it's just going to depend. But I would tell employers to remember that under the ADA, you're still looking at modifications of a work schedule. You're still looking at transferring marginal duties, if possible. There's a myriad amount of ways to skin this cat.
Yeah, I think a couple ways to fill in the gap on that catch-all is check out the CDC, right? Because the CDC is going to have pretty good guidance on their website about what to do in those situations that aren't the cookie cutter situations. If it's a supermarket, right? You talked about this, putting up the barricades, putting up the plexiglass between a cashier and a shopper. That's easy. But you don't know what you don't know. And presumably the CDC is going to be the first large government agency to fill in the gaps. So that's a website you should be checking out. Also,
as well as OSHA.
What's that?
As well as OSHA.
OSHA, of course, and JANS. JANS is not, they're not an official administrative agency or government website, but the Job Accommodation Network, jans.org, awesome.
AskJans.org.
Thank you, askjans.org. Whoever has jans.org is getting some extra hits right now. Askjans.org is...
I'm sorry, Eric, it's singular. AskJanORG.
Oh, well, then everyone's getting hits here. AskJan.org. Sorry, I should have this memorized. I have it bookmarked. That's why I don't memorize URLs. The only URL I memorize is theemployerhandbook.com and fisherbroyles.com. But AskJan.org, great website for workplace accommodations generally, but they have a whole COVID-19 section. So check that out as well. I see that we're getting a ton of questions that are streaming in on the side. We'll get to those in a bit, but should we run through? Bless you. Bless you. Should we run through some of the questions that were submitted beforehand?
Great.
All right. I have them in front of me. I will read some off to you, and we'll see how well we can answer these things in a non-legal advice, non-attorney-client privilege kind of way. All right. First question. If an employee, oh wait, this isn't the first question. I have different questions. Sorry. Ready? First question. If an employer which has less than 50 employees is exempt from the EFMLA and the EPLA, so they're does it still have to pay employees for 80 hours of leave relating to numbers 1, 2, and 4 on the poster? Let me translate that. I think there's a misconception here. The reader asks, if an employer which has less than 50 employees is exempt from the FFCRA, so that's our first problem. Does it still have to pay employees for 80 hours of leave relating to numbers 1, 2, 3, and 4 on the poster? That's the government order for quarantine or government quarantine or isolation order. That is an employee who is sick with coronavirus. That is an employee who has symptoms who is going to get checked out by a healthcare provider. And that is an employee who is taking care of someone else who's subject to the quarantine order or has coronavirus. So Amy, did you understand that question?
I did understand that question.
All right, let's get it. What do you think?
So what I think is no. I mean, employers who have less than 50 employees are not exempt except for that one reason, that number 5, I believe it is, that overlaps between the paid sick leave and the family medical leave. So that's number 1. Number 2, they're not going to have to pay the employees if the company's authorized representative determines and can show that the business cannot pay it for, one of 3 reasons, right? So it has to basically demolish the business is what the reasons come down to. If it's going to render the business, the pay will exceed the revenue, and it will really damage the business as a going concern. So it's just going to depend on whether the company can really meet those guidelines.
Right. It's a very narrow exception, that number 5. So, there's a reason that Congress decided that any employer with between 1 and 400, and really between 0 and 500 employees, 1 to 499, are covered under the FFCRA, because the presumption is you're supposed to provide this leave. So getting that exemption for reason number 5 is going to be difficult. But if you do want the exemption, if you're seeking the exemption, document it well.
Exactly.
This next question, I can handle this one. If an exempt employee has cold or flu symptoms and the employer tells him not to come back to work until he feels better, and the employee does not have any PTO, is the employer still required to pay him for the missed days? It depends. But if the employee is exempt and does any work during the work week, the default rule under the FLSA is, you get paid for that work week. Now, if you have a PTO policy, right, usually that pay comes out in PTO. But if it's someone who's just kind of told to stay home and the business is otherwise open, you probably get paid for that week. Amy, you agree?
I agree. Under the Fair Labor Standards Act, I agree.
Next question. What are your thoughts on the EEOC pausing issuing right to sue letters? Oh, right. So there was some news recently that the EEOC is only issuing right to sue letters upon request, and is not otherwise issuing the right to sue letters for charges that are pending at the EEOC. Will they continue to investigate but just hold on to the right to sue letters? Will it affect position statements at all, or the mediation process? I can speak to the mediation process. I am a paid private mediator, but I'm also a volunteer mediator with the EEOC, and I just conducted a telephonic mediation on, what day was it? Wednesday. And we settled. How about that? And I'm doing another mediation on Monday as the mediator. And I've been, once I told the EEOC, call on me. I'm free to do it again. I don't just have to come in person. I'm getting bombarded with requests. So,
Eric, I have one scheduled, a telephonic mediation that I was supposed to be traveling to Austin for. That is now a telephonic mediation scheduled for next month.
Yeah. So I don't know so much about the investigative side of the house, but mediation is humming along. We did it telephonically. I would have loved to have done it through video, but that's a little bit difficult because some people, usually the charging party themselves, might not be in a situation where they have great internet bandwidth or internet access to begin with. So we just did it telephonically. I had both sides keep a conference line open, and I would just dial in when I was ready to talk to whatever side I was ready to talk to. And it took a long time. I mean, it's longer than a live mediation for sure, but it worked. We settled.
Yeah, no, but I mean, to answer the original question, I think it makes sense to pause issuing the right to sue letters I mean, I think that people will miss deadlines. There's a much greater potential to miss deadlines, and that would make me nervous. So to me, I think it makes sense. I don't know, the EOC probably investigate via email, I would guess.
Yeah, I suppose. But I haven't. I mean, I have at least one or two matters pending at the EOC on the investigative side, and I haven't heard anything. Next question. Can you please help with a clear definition for, quote, experiencing COVID-19 symptoms and seeking a medical diagnosis? So this is leave reason number 3 for paid sick leave. Amy, what about this experiencing COVID-19 symptoms and seeking a medical diagnosis? What does that mean?
Because my JD does not include an MD, I would really advise everyone to check with the CDC on this one, or go to a healthcare provider to get checked out. Generally, what the CDC website says about COVID-19 symptoms is that dry cough, fever, chills, extreme fatigue. There could be some stomach upset, and the like. Yeah. So it's just a matter of checking in with your doctor, checking in with the CDC, and what they have to say about it.
Okay. Here's a follow-up question from the same person. They said, we have an employee wanting a few days off because of suspect symptoms. Yeah. And then want to come back and be paid using PTO. Should they be quarantined for 14 days? So someone who says they've got symptoms that start to sound like coronavirus, should they be quarantined? I think based on the latest CDC guidance, if it's an essential workplace, the answer is no. If you're well, strike that. I mean, if you have the fever and stuff like that, then the answer is yes. But let me walk this back. If you've been exposed to someone who has symptoms or actually has coronavirus, and you yourself don't have the symptoms, right? The CDC has just said you can come to work, just take some precautions and work in an essential workplace. Once, however, you develop the fever and you start to have the symptoms yourself, so you're no longer asymptomatic, should you be quarantined? And I think the answer there is yes, right? Right, Amy? I just literally did a 180 there, but yes.
I mean, I think this was a tricky issue with the CDC yesterday, because we know that the virus can exist in a person for 14 days and that they can be asymptomatic. So, the CDC recent guidance is saying no, but I think that can be contrary to what we have talked about with our clients recently, and I think the fact that the virus could live for 14 days should factor into that decision. I also think that this is a question for a medical provider, and I would caution everybody to discuss it with the person's medical provider, or have the person discuss it with their medical provider and then provide you with information.
Yeah. Here's a question. I'm going to skip the next question. There's a question that came in that asks, can emergency paid sick leave be used sporadically? I don't know if the person meant to say intermittently or if they truly meant to say sporadically. If it's intermittently, the answer, well, it depends, right? It depends on whether you're teleworking or whether you're working at the work site. If you're working at the work site, the only way you can take paid sick leave intermittently is for reason number 5. That is, if you are caring for a child that has no school due to coronavirus, or child care is unavailable due to COVID-19. If you are teleworking, then you can take intermittent leave for any of the reasons, including reason number 6. I'm not going to get into reason number 6 yet. We're not going to tease reason number 6, but you can take it intermittently provided that your employer allows it. So the employer holds the cards. If the employer says no intermittent leave at all for any reason, work or telework, you're SOL.
Right.
But the Department of Labor has encouraged employers to be flexible, pragmatic about this. So if you are out of the workplace, teleworking, you can take it intermittently, but you just need to come up with a leave schedule that that works, that your employer agrees to, and it's then only that time that you take intermittently for which you get paid.
Right. And I would add to that the stress on the fact that the employer and the employee have to agree to this, and that this varies from initial guidance that we were getting around April 2, I believe it was, where we thought, maybe it was even earlier, where we thought that the FFCRA would simply follow the FMLA in allowing for intermittent leave. Now, it's not a blank check. It's not, you have to allow it. The employer and the employee have to agree.
That's right. And to close the loop, the reason why you can't take intermittent leave if you're working in an essential workplace on site is because we just want to protect the workplace, right? We don't want someone going home for a couple of hours if they have coronavirus, taking Tylenol, coming back to the workplace and saying, oh, fever's down, I can work now. No, that doesn't work. So that's why when you are literally exposed to the virus, we don't want you coming to work at all, let alone intermittently. Amy, we got some CARES Act questions. You feel good about that?
I feel okay about that. I feel okay. So
these are softballs. And we've had a chance to look at these questions before right now, so hopefully we can answer a few of these. Here's the question. Can my grandson, who runs a new online business from our basement, apply for a CARES Act loan to help him with the loss of revenue due to COVID-19? Doesn't pay rent, he's got no employees, he had no income last year.
So let's talk about the payroll protection program for a minute, which is one of the programs under the CARES Act that was passed just recently. So a lot of you, I'm guessing, have applied for a loan under the PPP or are doing so today, like this person's grandson, because they're an independent contractor. So I've been involved in our firm's efforts to kind of convey information about this program to our clients, to our partners, to our friends, to the public, from the employment perspective, from the business perspective, not from the tax perspective. Do not ask questions about tax to me. But the issue is you apply for a loan. It's based on your past payroll costs. I'm giving a giant generalization here. And you can obtain 100% loan forgiveness if you're using the loan for certain reasons, which includes payroll costs. Okay, and that had a very specific definition. But the bottom line is this person's grandson would be considered a sole proprietor or an independent contractor. And a sole proprietor or an independent contractor can apply for a PPP loan under the CARES Act to help him out, as this person has asked. It does allow for that, and those loans, they can, sole proprietors or independent contractors can apply for those loans at their bank starting today.
All right. Thank you. Shall we, I'm just eyeballing here to see if we have any other CARES Act questions, because it would be good to chunk those together. I don't see any just yet. People seem to want to know more about FFCRA, so let's give them what they want. Hypothetically, Amy, I love how the person prefaces this. Thank you. All of these questions are hypothetical.
They know you.
Just how specific does the employee or employee's doctor have to get when talking about the employee's underlying health condition to get to the employee being particularly vulnerable to COVID-19 in order to qualify for EPSL? So we're talking about leave reason number 2, right? So you yourself, you have coronavirus or something, I'm not quoting from it right now, but basically that makes you kind of susceptible to it or immunocompromised to it, or basically it is particularly vulnerable to COVID-19 is the exact language. Is it enough to say something like, my doctor said I should stay home because of my health? Thanks. I have thoughts on that, but do you want to take a first crack on that, Amy?
Sure, and then I'd love to hear your thoughts.
Okay.
So the rule, the language of the Families First Coronavirus Response Act, and we're talking about paid sick leave here, just says that the person's healthcare provider advises the person to quarantine due to concerns related to COVID-19. I mean, that's what it says. But we get some guidance from the Department of Labor saying that a healthcare provider is anyone employed at any doctor's office, hospital, healthcare center, clinic, retirement facility.
Let me stop you. So let me
Yes.
stop you there. So two different parts of the healthcare provider. There's the healthcare provider dichotomy. We have the healthcare provider who can be excluded from coverage under the FFCRA. So if you work at a doctor's office, you work the front desk at a doctor's office, you're not performing surgery, you're literally admitting the person, helping them with the paperwork, the person upon whom surgery is going to be performed. That person can be excluded from getting the paid sick leave or the expanded FMLA. That's the expanded definition of healthcare provider. At the other end of the spectrum, we have the classic FMLA definition of healthcare provider, and that's the person to whom you go to when you want to get certified for FMLA leave. So I think in this particular situation, going to the healthcare provider, like the doctor, for me, I think of this in terms of just getting the tax credits. Like that's really what this is about, documenting your file to make sure that you can get the tax credits. And really all the IRS is asking for is your name and the name of the doctor who you saw. That's really it, right? And if an employee puts that on a piece of paper, signs it, or puts it in an email, I think you're good to go. If you want to push back because you think someone is full of it, I mean, I guess you can. That you're within your rights to do that. But as far as the IRS is concerned, it's just your name and the doctor's name. That's really all they want. Let's see. Next question. What options does an employer have with abuse of emergency paid sick leave? Amy, 6 months from now, hopefully we never have to repurpose this presentation. Hopefully we're done with FFCRA on December 31st, 2020. But why is it not shocking to me that we have an HR professional asking about abuse of leave?
I mean, we're in a pandemic,
right?
You don't want somebody in your workplace if there's any question. We're in a pandemic. I mean, I guess I would say we would encourage you to work it out, and try to figure it out. I know that employers are frustrated. It's such a chicken and egg situation. If you're running an essential business and you're trying to run your business, but people don't want to come in and things like that. But abuse, I would say, and correct me if you think differently, Eric, is not something we're really focused on here. We're focused on keeping people safe, keeping people healthy, having your business run, to the extent that it can, and treating your employees with some humanity to be able to do so.
I think it's all well said. I don't have anything to add to that. I think it's just really well said. The balance between doing what's right and doing what's legal has never been more important. I can't remember a time when it was more important than it is right now, because we're in unprecedented times. Let's see. Oh, here's a good question. And I got this yesterday during the Zoom chat that we did for Pennsylvania and New Jersey employers. And if you want to check that out, folks, it's not, we got a little beyond Pennsylvania and New Jersey, and it's on the Employer Handbook YouTube page. So if you go to any of the recent blog posts, especially today's blog post, there's a link to the video that we did yesterday. And when you head over to the Employer Handbook YouTube page, make sure to subscribe. That way you will get notified when we upload new videos like this one. We'll upload this one when it's done. So one of the questions that came up was, does childcare due to school closing reasons for PSL and EFMLA disappear once the usual school year ends? Well, that's a good question. What do you think, Amy?
I thought so too. I mean, I can't imagine that it would. How could it apply if the school year's ended? But I mean, I confess, I don't know. It's a good question.
Yeah, I can. Here's my thoughts on that. If you have school age kids, younger school age kids, let's say under 14, right? School year ends, and let's say they're not going to camp over the summer. They don't have daycare. You're responsible for them. I think you may be able to get some. You may be able to get some EFMLA there. I don't know that necessarily that it would be any easier at that point to find childcare for them. I think the same COVID-19 concerns are going to be in play. So, excuse me. I think there's the potential that you could get some EFMLA for that. Certainly, hopefully this all abates by the time school starts back up in August or September, depending on whether you're in the north or south. But yeah, I think that's a very good question. And that might be one of those situations where, to use a baseball analogy, the tie goes to the runner, and maybe if the government's going to be okay with it, you give the employee that leave. Really again, a lot of it comes down to, can you get those tax credits? And if you're going to get the tax credits after the school year ends for providing the leave, then why not provide the leave?
Right. And I would say it's not just, the reason isn't just about a school closure. It's about not having childcare.
Exactly.
And even though maybe an 11-year-old doesn't need full-time childcare, you probably, can't be working for 8 straight hours a day and ignoring the 11-year-old either, So it's more than just school closure.
Yeah, I see a comment flashing by on the live chat. Heather wrote, if camps aren't available in the summer, ... The answer, I can finish that sentence. My kids are going to go nuts. I don't know, and I don't know what I'm going to do. Okay. Here's another, just a statement. Would love more guidance on when PSL can be used for quarantine or isolation order. I think I'll start, and then Amy, feel free to chime in. So this is a pretty narrow exception, or I should say, a narrow way to get PSL in practice. I know that a couple members of that Senator Patty Murray doesn't see it that way, and Rosa DeLauro from Connecticut, Congresswoman DeLauro, don't see it that way, and some of the other folks on Capitol Hill don't see it this way. But here's how the DOL has interpreted it. Basically, if your work is shut down regardless, they use the example of a coffee shop, okay? Let's say you work as a barista at a coffee shop, but the coffee shop is closed because of coronavirus. At the same time, you're subject to a stay-at-home order, or I use the term stay-at-home order loosely, safer at home order, quarantine order, whatever your state calls it, right? Your governor has said you can't go out unless you need to go to the grocery store, or you got to get, some medicine, or you're taking a walk, or whatever it is. If you're that barista and the coffee shop for whom you work is closed and you're subject to a quarantine order, you don't get paid sick leave because the business is closed, okay? If you can telework, it's no longer a coffee shop situation. It is, you work for a law firm. like Amy or I. Amy and I can telework. We telework all the time. That's what we do. We work for the largest distributed law firm in the world.
Full-time telework.
It's we try because there are kids at home now, but we telework. We can't get paid sick leave. Okay. Where you can get the paid sick leave is where the quarantine order is what causes you to miss work. Okay. So really the classic situation, it's only been around for like 2 weeks. The situation would be you work for an essential business and for some reason in your state, there's not a carve out in the quarantine order that you can go to work for your essential business. I think every state has that exception, but for some reason your state doesn't, right? So literally the quarantine order is what's keeping you from leaving the house to go to work. Okay. That's when you can get the paid sick leave. That's pretty much it. Yeah. It's got to be the but for cause, to get real, all legal on you because of. That's it.
I agree.
We have a Pennsylvania and New Jersey unemployment compensation question, which, sorry to the person who submitted this. I'm going to skip that one. I think I'm going to alienate a bunch of the audience if we answer that. But I'm going to scroll back up through the chat since we have about 10 minutes left. And let's see. Feel free to add some questions to the chat. Let's see. Paige asks, thoughts. Doctor's note for an employee that states that the employee is at high risk for complications should he contract COVID-19. No direction to self-quarantine, no timeline. Do we accept that for paid sick leave? Did you get all that, Amy?
Yeah.
What do you think?
And I would say yes, given the fact that, I just had this question actually from an individual who is an anesthesiologist and she's immunocompromised. She takes immunosuppressant drugs and she requested the leave in order to not be in the medical setting because her risk at developing COVID, complications from COVID were much, much greater. They didn't ask for a doctor's note. It was no secret that she was on these immunosuppressants. Like, let's not do form over substance here, I guess is what I would say. If somebody has cancer, do you really need a doctor's note? Like, who's making that up? Nobody is making that up. I think for the tax credits, you want to have some kind of documentation, as you said before, Eric. But I think that if people have an underlying condition that puts them at risk of extreme complications, you should kind of go with that.
Yeah. And while we're on the subject of documentation, I've seen some posts recently on the internet about what kind of documentation, if any, employers should be requesting from employees in connection with FFCRA leave.
Did you see my Twitter argument? Kate Bishop and I had a Twitter argument.
Yeah,
with another lawyer.
Yeah, I don't want to out anyone, Kate. But I am firmly on hashtag team forms. I think forms are really important here. That's not to say that you can't provide the leave initially if someone makes an oral request. In fact, the DOL says you should provide the leave if someone makes an oral request. And I think you could follow that up with an email. I think an email would probably be good enough to document. It's not signed. The DOL has alluded to a signature, but I think an email would suffice, something memorializing an agreement between employer and employee about why they need the PSL or the EFMLA. But I think you should have a form.
Let me say something about that. Generally, look, we have forms, we provide forms, they're pretty readable and in plain English, and I like that. However, the rule says an oral request suffices. So I wouldn't want anyone to deny the leave because there's a form and the person hasn't filled out the form.
That's right.
So that I would encourage people not to place quote, form over substance, pun intended.
I see what you did there.
I know, COVID humor, right?
Yeah.
So
there's not much of it. We need it where we can get it.
I know, right? Another thought that somebody had was like kind of a checklist, using a checklist as opposed to a form if needed, and getting that email with the person's name, the dates, and things like that. So I just want to make it clear that you can take an oral request. I wouldn't want you to inadvertently, take something away that might get you into trouble.
I mean, and another option too, anyone in the comments, just shout out if I'm being incredibly naive. But if someone doesn't have a printer at home, if they don't have the wherewithal or ability to print something out, sign it, and send it back,
Scan it.
Or scan it. Couldn't you, as the HR administrator, or you as the company, who's ever in charge of administering this, put a form in the mail, right? Put a self-addressed stamped envelope, and just send it to someone, and say, "Look, fill this out, sign it, put it back in the self-addressed stamped envelope, and put it in your mailbox." Wouldn't that work?
Well, I mean, mail delivery is such an issue right now. I will say, and I didn't say this on the whole Twitter argument, there are free scan apps. I mean, I can scan a 10-page settlement agreement, but to scan one page and then email it is so easy.
Yeah.
So easy.
Yeah. Yeah. I mean, but oral request is fine. But that's why I think the forms, I mean, would you use this in another situation where someone's taking classic FMLA? Would you say don't use forms because
no, look, I'm an employment
someone's
lawyer.
at home?
I'm an employment lawyer. Written documentation is my life. Email confirmations, no, I don't like text for this. Text I'm not a fan of. Somebody asked that with most issues. I'd rather have an email if nothing else.
Amy, how you feeling? We're getting close to the hour mark. Do you want to go for a little bit longer, or should we? All right, we might go into overtime, folks.
My kids may or may not still, be standing.
Okay, that'll be the final bell when the kids start bombarding us. Here's a question: what if a healthy employee provides a doctor's note stating they can't work? What is our obligation?
The question would be, why does the doctor say you can't work? What's the situation? That's at the point where I would kind of use the ADA's interactive process and ask that question.
Yeah, that might not be a COVID-19 issue. That could be an ADA issue. That could be an FML, just a regular old FMLA issue. Yeah, that's like push back maybe and say, why can't you work?
Yeah, ask.
Yeah.
Ask. That's weird.
Here we go. Here's a hypothetical. This is from a lawyer. Outside of expanded childcare leave, all right, this is a hypothetical. An employer wants to move to a 4 per week for a few months. Can an employer require employees to use up their PTO for that 1 day each week, rather than reduce the work week and have employees file for unemployment? Assume Pennsylvania law. I'm not going to assume. I'll assume any law. But I see what you're saying. So we're going to go from 5 days a week to 4 days a week and have the employees use PTO on the 5th day. Well, there's that one issue, whether you can do that or not. But let's assume that you can do that. At least I will say the Commonwealth of Pennsylvania. What the Commonwealth of Pennsylvania has said is that if as a claimant you are able to get paid time off from your employer first, you'll need to run that out first and exhaust that before you can get the UC benefits. So I don't know if going from 5 days a week to 4 days a week is enough to trigger on its own. Let's forget that PTO day is enough to trigger getting unemployment compensation. It's probably not enough of a drop in hours. But if you went from like 5 days a week to 1 day a week or 2 days a week, that's going to be enough. And I'm pretty sure if you get those hours, even if you're working on a part-time basis, if you get that unemployment compensation, boom, all of a sudden you're eligible for that CARES Act $600 a week called a stipend or topper on top of that. I mean, any unemployment compensation, you're getting that $600 a week from the government. Yeah.
I think it's going to depend on the state, and states, having looked at this for our firm, at a wide variety of the unemployment compensation agency websites, it's really going to depend, and it's a very state specific question.
Okay. Here's a hypothetical question regarding EPSL. I have a hypothetical question. An essential business has established proactive coronavirus prevention rules. Great. Employees who have any flu-like symptoms are not allowed to come into work and will have to self-quarantine for 72 hours per the CEO. Since the employer forced the employee to self-quarantine, would the company have to pay emergency paid sick leave? So it's a company mandated quarantine, not a government mandated quarantine. What do you think, Amy?
I mean, I've had this question, and I think that's a distinction. That's not provided for under the Families First Coronavirus Response Act as a reason, as a basis. I mean, I think practically, if you as the employer order people to not come to work, you should pay them. I mean, that makes sense to me, but it's definitely not a question. It's not one of the reasons by which employees can get leave under the FFCRA.
Certainly not under leave reason number 1, because it's not a state, federal, or local quarantine. But if the company forces you to quarantine and your first stop once you get in the car to leave the office is a beeline to the emergency room to get your symptoms checked out, that's PSL time. That's PSL time right there. The time you spend waiting in the ER or at urgent care, when you're spending time to get checked out for symptoms, you're getting PSL. Let's see. Question. Oh, hey, David, how you doing? Hopefully he's still on. David from Nebraska. What about EPSL for a week, then no longer needed, i.e. childcare becomes available? Then can the employee then use the second week at a later time for another reason? Yeah, I think the answer is yes.
Yeah, and we address that. I mean, if they agree. If the employer and the employee agree that it can be used intermittently, then sure.
Let's see. Here's a question. Just to clarify, an employer cannot require an employee to use regular PTO during the first 2 weeks of FMLA plus if the employee doesn't want to use their PSL during those 2 weeks. I think the answer is, actually, I kind of swallowed those last words. Let me repeat that. Just to clarify, an employer cannot require an employee to use regular PTO during the first 2 weeks of FMLA plus or EFML, whatever we're calling it, if the employee doesn't want to use their PSL during those first 2 weeks. And I think the answer is yes, because during those first, yes, the employer can't require, or no, the employer can't require, because under the FFCRA, an employer can't require an employee to use PTO before the employee uses PSL, right? The employee can make that election. The employee can say, I want to use my PTO first, and then I'll use my PSL. But if the employee is taking leave for EFMLA, which overlaps with reason number 5, EFMLA is unpaid for the first 2 weeks by default. So if during those first 2 weeks the employee says, okay, I don't want to be paid, I don't think the employer can insist during those 2 weeks. However, and I think this is debatable, but I think I'm right. If the employee says, I want to be paid during those first 2 weeks using my paid sick leave, I think the door is then open for the employer to run PTO concurrently during the first 2 weeks, because you're not providing the PTO before PSL. You're providing it alongside the PSL, just like you would in any FMLA situation.
Yeah, I would agree with that. And that was the situation we were noodling over this weekend. And I know that's a mouthful for you guys. I was kind of struggling to process as well. And the reason being, and one thing we haven't talked about, which I'm sure Eric has talked about before, is the leave, may or may not be that much money for your employees, depending on what they're making. Remember, these leaves are capped. In some instances, $200 a day for the expanded FMLA. The paid sick leave, it can be whatever it is, 200 something a day. And no more than a certain amount. They're capped. So it makes sense that an employee making more money, is going to, more than minimum wage anyway, is going to want to use their PTO where they can be fully paid, or at least where that leave can be topped off by use of their PTO.
You ready for another question? Yeah. All right, you ready? This is from Nixie. She says, if an employer said not at all for any I'm sorry. It looks like she might be answering. No, okay. I probably should have read this before I started reading it. I'm going to skip this one because it looks like it might be an answer to another question.
Okay.
How can an independent contractor be eligible for unemployment under the CARES Act? Do you know?
You're Pennsylvania. I'm going to let you take that.
Yeah, I don't know.
That's an Eric question.
Yeah, I'll be honest, I don't know the answer to that question.
I'm just fired in Virginia.
I'm going to say it depends. Hypothetically, if an essential employer chooses to close business for safety reasons for a few days to allow for cleaning, is the business required to pay employees? I think the answer is it depends.
I agree.
Yeah. The answer depends on a couple things. One is, who is the employee? Are they exempt or non-exempt, right? If it's a non-exempt employee, then no, you would not be required to pay those employees, assuming they're not, doing other work. If it's an exempt employee, then yeah, you may be, if they're performing any other work during that work week. Yeah.
Right. Even via telework. And that said, as we discussed earlier, you may want to pay them. It's an employee, and well, it depends. It depends on the business. I have a lot of clients right now who are begging their employees to come to work, and their employees maybe don't want to because they can make more for unemployment and this, that, or the other thing. So you want to be an employer who, when this is all over, your employees want to come back to.
Oh, and I know exactly what business this is because this actually came from a client. So we can talk about that one offline in more detail. Here's another question. Could an employer get tax credits if all employees are being paid due to shelter in place? Some don't have to telework but are being paid. Okay, so I think the answer is yes. I mean, if you're properly providing the leave to someone who has to shelter in place, document it, you'll get the tax credits. If you're giving someone leave who doesn't qualify for shelter in place, but you're giving it to them anyway, then I think you're going to have a much tougher time getting your tax credits, right?
Correct. The IRS lays out the forms that they would ask for to claim tax credits, and the documentation based on whatever reason it is in order to obtain the tax credits. They lay it right out there in bullet point form, which makes my heart happy.
You ready?
Yeah.
ERC credits under 100. Do you know what am I missing? ERC credits. Do you know what that is?
I do not.
Okay. We're going to skip that question because I don't know. It's been an hour and 10 minutes, and maybe that's something I should know right off the top of my head, but I'm not sure what ERC credits are.
Emergency something? I honestly
sure.
I don't know.
Oh, here's a question. Philip asks, what documentation can an employer require for leave reason number 3? So that's the one where you're going to get checked out by a doctor because you have the symptoms. Do you want me to answer? Or do you know that one?
I mean, you can have a doctor's note.
Name and health. I think it's just doctor's note for sure, but name and healthcare provider
right.
is what does it. Here's a couple. I'm just seeing some good comments here. Susan, we were talking earlier about the whole form discussion, and Susan says I offer to complete the form with people on the phone, and I think that's a pretty good suggestion as long as ultimately validated at some point. Can you use text message? Sure, you could, as long as all the information is in the text message. I think that's a pretty good one too.
Though, like I mentioned this earlier, I would caution against the text messages, or at least if you're doing it by text message, then forward it to your work email, because text messages can get easily lost. They're not secure, etc. You want to be able to get these tax credits from the IRS.
Yeah. I mean, other people are writing in, banks are open, they can notarize in fax, UPS stores are open. This is true. Actually, I have a post office box at a UPS store nearby, but I have not been there in a few weeks. So if you've sent me mail, I'm sorry that I haven't gotten back to you. Let's see. Is unemployment paying the additional amount of hours? Is unemployment paying an additional amount if hours are reduced or only for furloughs and layoffs? I think it varies on the state level. It varies state by state, but at the federal level, once you're eligible for unemployment, like $1 of unemployment, you can get that $600 a week on top. Yeah, I think.
And it's for 39 weeks instead of the usual 26 weeks.
Okay.
Which is nice.
Yeah. Here's a question. Here's a comment. Don't forget that the $600 from the government and all unemployment insurance payments are taxable. It's a good reminder. It's not free money.
Taxable to the employee.
Yes.
As income.
Yeah. Hypothetically, could an employer terminate an employee for not following the COVID prevention and social distancing? Interesting.
I mean, I'm going to go out on a limb here, and I'm going to say yes.
I'm going to say yes too. Now, it could vary from state to state, and my only pause is states like California and Colorado, where neither of us is licensed to practice, and for sure neither of us is providing legal advice. But those states have off-duty conduct laws. But in those states, we're talking about an executive order that say, stay home. You must stay home. You must follow social distancing. You must follow certain COVID prevention steps.
Oh, I thought we were talking about in the workplace.
Oh, heck yeah. Fire someone for anything. Yeah, sure.
Yeah, I thought that was in the workplace.
Oh, I thought it was like you saw a Facebook post of someone going to a kegger at the neighbor's house, not following social distancing. Can you fire him for that? Let's see.
A kegger.
Sorry. Get a little punchy here at the hour and 15-minute mark, and I think if we have one more question, we're going to wrap this up. Wait, this was the same one, or this was a variant. Can we discipline an employee for not? I love these questions about can we discipline. This is true HR. I love it. Can we discipline an employee for not following social distancing and getting in contact with someone that tested positive for COVID-19? I think the answer technically is yes. I think the problem you're going to run into with that, practically speaking, is if someone hasn't followed social distancing, how are you going to know that? Okay. Once they come to you and ask for leave related to COVID-19, I need leave because I've tested positive. If you fire them because you believe they were stupid and didn't follow social distancing guidelines, right? Okay, I guess that's a legitimate business reason, but at the same time, there's a built-in anti-discrimination, anti-retaliation provision in the PSL portion of the FFCRA. So I think if you fire someone like right around the time that they're requesting that PSL, you're going to get sued.
Yeah.
And you're either going to lose or you're going to go all the way to trial and spend over $100,000 to find out if you're going to win.
Just pay to leave.
Yeah. Amy, I'm tapping out. I'm tapping out. On that note, I'm tapping out. I want to thank you for stopping by and yeah, and making this for sure the best ever employer handbook Facebook live chat that we've ever had. For folks that hung in there with us, thank you. I am going to, once this is over, it'll be available on the Facebook fan page. It'll be available later this afternoon on YouTube, on the fan page there, on the channel, and I will post links in Monday's blog post. Amy, any parting shots? Do you have anything you want to plug?
Yes. Thank you very much for having me. Very much for having me. I thoroughly enjoyed this. We are happy to take questions anytime. We're both at Fisher Broyles. Come visit our new website anytime.
Oh, yeah.
Just remember the disclaimer that none of this was legal advice, even though it was delivered by lawyers.
Thank you, Amy. And then to folks that haven't connected with Amy yet on LinkedIn, look Amy up. She's a pretty proficient LinkedIn user. Look Amy Epstein Gluck up on LinkedIn. You can connect with her there. You can find our bios at Fisher Broyles. That's FisherBroyles.com. I will add Amy's contact information in the description section of this video, both on Facebook and on YouTube if you didn't get all that so quickly. So thanks, everyone. Have a great weekend.
Thank you.
Bye-bye.
Good to talk to you. Bye.